We would like to welcome you. Presenting today are Hinshaw attorneys Tony Antignoli, Mark Carter, and Michael Weiss. Tony Antignoli is a partner at Hinshaw's Labor and Employment Group. Tony focuses his practice on advising clients on issues relating to employee benefits and federal taxation. Mark Carter is a partner at Hinshaw's Commercial Transactions Group. Mark's practice is concentrated on commercial transactions, corporate governance, finance, and business insolvency. Michael Weiss is a partner in Hinshaw's Commercial Transactions Group. Michael has negotiated and closed hundreds of corporate and commercial real estate transactions. This webinar will cover preserving business cash flow when cash isn't flowing, lender issues and obligations relating to defaults, the specifics of tax relief programs from the IRS, including delayed filing and payment deadlines, employee benefit plan strategies. Thank you all for joining us. Let's get started.
Okay, Michael, thank you. This is Mark Carter. Let's start with a business owner's checklist for planning for the future. Many companies are facing circumstances that they haven't faced before, to state the obvious. How long will this last? Will we return to normal once it's over? Given these uncharted waters we are in, it makes sense to look to a few of the rules and tools applied by turnaround professionals to businesses in distress. So let's start there. It's important to note that no one revitalization method fits all circumstances. In fact, they will be significantly different depending upon whether you're an essential versus non-essential business, a highly leveraged enterprise, a liquid versus a cash-strapped business, and even among sub-industries. Every circumstance is unique, and the responses will accordingly be different. Let's keep that in mind as we go through some of the general rules today. In this new normal, let's look at a few insolvency concepts that business owners should be aware of. Chances are insolvency laws will apply to various actions and transactions that you face. One significant change that owners, managers, directors, partners need to be aware of is that their fiduciary duties expand upon insolvency. Those duties and obligations, a duty of care, duty of loyalty, an obligation of good faith and fair dealing, are governed by state law and may vary depending upon the state of formation. When an entity becomes insolvent, those duties generally expand to include creditors of the entity. So when formulating a transaction, the rights of creditors generally need to be considered. Similarly, typical approaches for limiting or allocating risk in acquisitions need to be adapted or enhanced based upon insolvency laws which apply. These insolvency laws go back centuries but have been refined through today. Typically, those risks are addressed in the document, in the acquisition document, but when creditors are involved, additional considerations need to be made. Finally, it's good to remember that transfers to ownership become restricted under state law and are subject to greater scrutiny. So business owners need to be aware of these circumstances in this new playing field. Another relevant consideration in this new normal is the importance of a cash budget to identify realistic revenues and operations and cost cutting. While not a law, but equally relevant is the truth that during these times, cash is king. Preserving cash and reducing costs are approaches that every manager unfortunately understands today. Accordingly, businesses will want to evaluate and prepare a plan based upon the strength of its customers and suppliers, at least before considering government programs. Identifying the key suppliers is relevant throughout the life of a company, now that it's perhaps life or death, it's incredibly important. To help a business effectively evaluate revenues and costs, and to use in negotiations with lenders and key vendors, as we'll talk about in a minute, businesses should consider developing a cash flow budget of the type that lenders are used to seeing. There are alternative cash flow processes that a company can follow. Many lenders like to see a 13-week cash flow budget. 13-week cash flow budget offers a more granular review of revenue coming in and expenses going out of a business. It's long enough to give management good direction, yet short enough to avoid purely speculative estimations. There are templates available to prepare these types of budgets, and they can be done internally or by an outside consultant depending upon the intended use. Hopefully these rules and concepts will help business owners address the challenges ahead. I want to turn now to stabilizing the business and conserving cash flow when cash flow isn't flowing. Since in these times cash truly is king, let's look at a few relevant sources of cash flow when that cash isn't flowing. For leverage business, one obvious option is to consider approaching the lender for help. After fully reviewing your loan documents, you should consider communicating with your lender. The circumstances for which you're communicating with the lender will vary, but you want to make sure you've reviewed all the covenants, the reps and warranties that a lender may be basing its decision on in talking with you about extending loans or making cash advances. Ideally, you'll speak with your lender about concessions or extensions before loan payments come due or covenant defaults arise. A cash budget in hand to help explain your circumstances and how you're going to pay back the loan would be helpful. You may want to point out why the concessions that you're asking for are relevant. Now may be a good time, unfortunately, for reaching out to the lender. Federal banking regulators recently announced recommendations giving lenders some leeway in working with borrowers on loan modifications without requiring the lender to categorize the loan modification as a troubled debt restructuring. So we've talked about going to the lender before loan payments come due or covenant defaults arise if you're seeking an extension. One common approach being performed by borrowers is to draw down lenders' lines of credit. It may be important at the time, but a word of caution is warranted here. Loan documents frequently include reps and warranties by the borrower each time a draw is made. If you ignore those reps and warranties and borrow when you're in violation of a covenant without communicating with the lender first, you may cause disruption in the relationship and problems down the road. It's always a good idea to consider speaking with your lender about extensions and credit draws before you do them. That said, every relationship is different, and one approach does not govern all cases. If you do negotiate with your lender to either defer payments or borrow down lines of credit, you can expect to be requested to enter into some type of forbearance agreement to preserve the lender's rights. You're essentially asking the lender to forbear, and so it's a reasonable accommodation to enter into a forbearance agreement for your relationship. These agreements will typically include waivers of lien defects, confirmation of circumstances, and releases. You can also expect tighter controls over the business and funding, at least for the forbearance period. In light of these circumstances, you need to have a clear understanding of what your cash needs are, because you may be giving up rights. Another source of cash flow are the many emergency funding programs by the governments that are out there. Others are being developed as we speak. It's a fluid process. We're going into uncharted waters, and having that government support is important. We're going to address a few of those specific federal programs later in the presentation, so I won't address them here. Generally speaking, though, the federal programs are very expansive and appropriately so. That said, don't ignore the many state programs that are out there. Most states have enacted measures that in many cases target industries relevant to that state. We hope to have a list of sources of state programs available for you after this webinar. For all these programs, there are a few things to think about in evaluating them. Do the programs require lien subordination or other concessions from your existing lender? If so, that discussion with the lender that we talked about earlier may take on more relevance. Also, be watchful for programs that have limits on either Program A or Program B, but not both. Having that cash budget in hand will help you target better the program that fits your needs. As these develop, I think the lender, the regulators, and legislators are removing some of these limitations, but you should continue to be watchful for the issues. Other sources of revenue and cash flow will become obvious as you and your budgeting team look for them. Business insurance is one frequently cited source in this season of webinars. However, policies should be reviewed if you actually have them. Some policies contain virus exclusions and are limited in scope. You should make sure that you've spoken with a competent advisor to make clear of your rights. Other sources, monetizing causes of action. I represented a lender and still do who advances litigation funding, and worked with a company who had a patent infringement claim, or a series of them, that the company was able to monetize in a way that didn't impact the existing lender's rights. The lender wasn't going to lend on it anyway. So the company found a nice source of cash without impacting its existing credit facilities. The final source to talk about today is somewhat basic, and that's extending payments to vendors and expense deferrals. The goal is to tide over the business now until funds become available. Frankly, given the climate, most of your suppliers and vendors are aware of the circumstances and will consider expense deferrals for a period of time. You may think that your vendors understand your cash flow circumstances and your need to extend, yet don't assume it. Like your relationship with the lender, be prepared to talk with your key suppliers and other vendors about your circumstances. With that cash budget in hand, you will be able to identify the key vendors over the relevant period. But remember, in talking with them, find out all that you can about their situation and circumstances. This data will help you formulate a better plan. Like with your lender, and perhaps more so with your vendors, you need to review or have reviewed the contracts which govern those relationships before going to them for concession proposals. This is a good point to move to the next slide. Okay. As the COVID-19 pandemic continues and perhaps extends over time, longer-term planning for disruption and distressed circumstances is prudent. Hopefully it doesn't go as far as we are hearing, but planning is important. And that is not to say that there aren't opportunities out there for strategics or investors with liquidity to retool, to pivot to a new product, or reposition operations. We all have experienced, perhaps, or represent even companies who are pivoting with existing operations to a new product given the new normal. In both of those scenarios, whether negotiating a rights to extend or drafting documents for a new deal, the concepts to follow should be considered. And as usual, the analysis always starts with the contracts. If you need to renegotiate them, or if you're writing a new deal, the words and terms of the contracts matter. In this season of webinars, you've probably heard a lot about force majeure and materially adverse change and similar contract provisions. To start, force majeure provisions are essentially contract terms that permit one or both parties to a contract to suspend performance or even terminate the contract. I would also add default and termination provisions to those relevant for your consideration and review. Remember, the words matter. A review of the contracts will help you identify rights that you may have to leverage the negotiation. In all these circumstances, beware of the notice provision. Rights that you have under contracts are no rights at all if they expire because your obligation to give notice of their triggering expired. So be aware of those and make sure you've reviewed all the contract terms as you are negotiating with vendors and possibly new deals. I also think it's important to take a look at your entity organization documents. What happens if one of your members of an LLC, for example, files a bankruptcy case or becomes insolvent? What rights do they have or you have? Being aware of your rights before the circumstances are present will go a long way to help you plan now for the future. Suppliers of goods, moving down the line, the page there, suppliers of goods are in particular need of being proactive in monitoring their contracts and rights and taking steps where necessary to protect their rights under applicable law, especially if their contract party is in distressed circumstances. Suppliers should review and be aware of the contracts to make sure they know when or whether the contracts impact stoppage in transit rights and when titles to their goods passes to the buyer, and other provisions like notice and termination clauses, among many. This is sage advice even in normal circumstances or times. Anyone who has been through a retail bankruptcy recently, like Toys R Us and others, this concept probably already hits home, but is worth repeating. Suppliers of goods need to be proactive in considering their rights and acting where appropriately. Finally, I think it's relatively fair to say that most businesses will be impacted in some way by the bankruptcy of a customer, supplier, tenant, or a tenant. It's relevant to know that the recently enacted CARES Act expands availability of small businesses' access to the bankruptcy process. It expands the debt limits to $7.5 million for both entities and sole proprietorships. It streamlines costs, so it's more favorable to a business with that level of debt, and only the debtor in those cases can file a Chapter 11 plan. All parties should be prepared for the impact of bankruptcy, and in particular small business bankruptcies on their operations. There are significant other provisions in that Bankruptcy Act that we need to be aware of, and you should consult your advisor where appropriate or where necessary. Thank you. And Mike, I think at this point I'll turn it back to you.
Thank you, Mark. Let's spend a few minutes, everyone, on lenders' considerations. sort of the flip side to Mark's segment of the presentation. COVID-19 is obviously causing business owners and borrowers to miss dates, delivery of financial statements, valuations, and so forth. First question is, how should lenders handle that? Naturally, lenders are agreeing to different extensions, grace periods, agreeing to further delays. Our suggestion is to be specific rather than general in the documentation. We would not suggest that delivery dates be open-ended. The lender and the borrower should have a conversation as to when will these statements be delivered, specific dates, not relying on outside parties, and if have to be extended again, so be it. But we are cautioning and counseling our lender clients to be as specific and detailed as they would be in the initial documentation, understanding that certain things will be delayed. So the takeaway is really specificity and documentation. Underlying all what we're going to talk about is communication and documentation. Whatever is agreed upon, let's get it in writing and let's get a commitment. Next question. Similarly, financial and other covenants are not being met or are likely not to be complied with in the near future. What should lenders do? First of all, we're suggesting that our lenders assess the situation. Which covenants in the documentation are not being complied with? Why is there, looking into the future, chances that they will be complied with? Is it just the timing issue? Every business is being affected differently by COVID-19, so there has to be an assessment and, of course, some flexibility, probably some waivers and some amendments, perhaps forbearance agreements, as Mark alluded to. But the lender has to have a clear assessment with the borrower and a clear discussion. And what is the industry? What are the chances? What are the financing sources to help the borrower out of this situation and get the borrower in compliance? And again, different lenders should check the documents, and it'll be a different resolution depending on the borrower and depending on the situation. But it's important that those issues be addressed, analyzed, documented. Next question. Do the negative economic ramifications of COVID-19 constitute an event of default? The answer, as it always is maybe. First and foremost, check the documents. How are events of default defined? Is it business suspension? Is it late payments? There may be several events of default given the circumstances, and those should be set forth in the document. How to handle or deal with those is mentioned above. Maybe there's a grace period, an extension, a modification, an amendment. Several of our lender clients are in discussions with clients, of course, about all of these issues now. So really, it just depends. It's unlikely that any loan documentation specifically refers to COVID-19 or even pandemics. There may be, but check the documentations. Check the documentation of the loans, but it's probably more likely that an event of default is a payment or breach of a covenant or business suspension or the like. Couple more questions. Again, as Mark alluded to, very popular these days is the question of force majeure. And force majeure means different things in different contracts. Words matter. Is force majeure defined as a natural disaster, an act of God, or the like. And there may be some uncertainty just depending on the definition. So force majeure is really not that different than many other legal concepts. It's typically defined in loan documentation in a definitional section or wherever. If it's not, it becomes really a question mark. Material adverse change typically is a little bit more defined in documents, and often it's in the lender's discretion whether to, call a default to determine as a result of a material adverse change, may tie to general circumstances or a specific event. In a typical legal environment, it's typically a high barrier to be a material adverse change if it's not specifically defined. Again, check the document. Clearly, in certain types of businesses, the construction, real estate development, a supply type of business, loan documents may be more clearly drafted because certainly if construction cannot continue, there may be a change, or if supply can't get supplies, that may be a change. So again, look at the documents, and if in the lender's discretion, a lender certainly could declare, and hopefully that will be enforceable. But it will, as discussed in the earlier questions, just probably lead to more discussions with the borrower. Final question for today is, should lenders document agree to extensions and the like with consents and waivers? The obvious answer is yes. But lenders should be very proactive in assessing a situation, anticipate further defaults rather than doing everything piecemeal, really review the documents, get a feel for the business, where it's going to go, and try to cover as much as you can in an initial amendment or waiver and so forth. So you don't have to go back every couple of weeks. Although certainly with this uncertainty, we all don't know the timing of everything, but please try and cover whatever you can. And we're anticipating and already working on many extensions, many waivers, many modifications, and we're all sort of in this together. This is obviously more convoluted in syndicated type financings or agency type financings, and be sure lenders keep their co-lenders involved in the process and make sure and review the reporting process, the voting process in syndicated financings. The key, we really believe here, is communication, information, and proactivity. A lot of common sense items, but and better to attack these issues early rather than later. Just a few words on each of the two SBA programs and that have been announced, and this information actually seems old already. We're in such a fast-moving environment. But two programs I want to mention. First is the Economic Injury Disaster Loan Program, which is really adopted in all states, up to $2 million in financing. Pretty short approval process of 21 days. It was being completed online as of last week, but I believe the SBA website sort of crashed, and now they're taking applications by mail. There's no revenue employee limitation. Any size company may apply. There are restrictions for a few businesses, such as cannabis. Interest rates are very favorable, 3.75 for for-profits, 275 for not-for-profits. Loan terms are up to 30 years, no prepayment penalty. This program does require collateral, does require projections, and the key thing, and I'm getting a lot of questions, is it's really supposed to be a financing for loss of revenue related to COVID-19. It's not just an opportunity to get a loan. You have to really have a compelling argument that you need this money because you lost revenue due to the pandemic. You cannot pay off or consolidate debt. That's not what this is for. There is a one-year payment deferral. The application was filed electronically. That's already outdated from 2 days ago. You will need 1 year of tax returns, your 2019 financials, 6 months projections, and there's an IRS form. So it's if your record keeping as a business owner is pretty good, it shouldn't take that long. If not, it's going to take time. The ultimate lender, I think there's a big misconception out there, is not the SBA. The SBA is really a guarantor. So the SBA is working with different banks that will fund these loans with a 100% guarantee by the SBA. So you may want to already start calling your potential lenders to discuss. The next program just came out the other day as part of the CARES Act is the Paycheck Protection Program loan. This program authorizes the SBA to fully guarantee loans. And this program is in addition to the economic injury disaster loan program. So you can't get the same loan for the same missing dollars, but you can get each loan if you qualify. Eligibility is any business, 500 employees or less. The loan is the lesser of $10 million or 2.5 times the average monthly payroll costs. And there's some detailed definitions that I won't go into here as regarding the math calculation. Term is up to 10 years. Again, these loans come from SBA-approved lenders also. Interest rates are no more than 4%. There's regulations and rules being drafted now as we speak. A couple other points to make that I didn't include on the slide is these loans are generally non-recourse. There's no personal guarantees, where the economic injury disaster loan do have personal guarantees, except there are carve-outs for guarantees if the money is not used properly. And again, the money, as mentioned, is intended to cover cost of payroll-related and other expenses from maintaining pre-COVID-19 employees. So if the money is used for something else, could be problems. And very importantly, there are provisions for loan forgiveness, which are a little convoluted and detailed. I'm not going to go into right here, but that's what makes these loans very attractive. And the SBA is expecting an absolute avalanche of applications. And we suggest, everyone and anyone who qualifies should take advantage of these opportunities. With that, I will turn the program over to Tony Antignoli.
All right, thank you, Michael. I appreciate it, and of course, for myself and our other panelists, first and most importantly, we hope that everyone is doing well, taking care of themselves, their families, their employees and colleagues. It's an unprecedented time. What our goal is for today is to provide some critical and timely information about the best way to manage through this crisis. Basically, we just want to be a resource to our clients, and the community during this time. What I wanted to talk about were a couple of my two main areas of practice are tax and employee benefits, so I wanted to address both of those, starting off with the tax issues. The IRS is, over the last few weeks, has issued unprecedented tax relief for just about everyone. They've taken actions that I haven't seen in my 20 years of practice. And we're going to go over all of them here. So first off, we want to talk about extensions of filing and payment deadlines, which I'm sure many of you are aware of. Tax filings that were due on April 15th, on tax day, have been postponed and are now due on July 15th. That's an automatic extension. No need to request anything from the IRS to get that approval. It also applies to all taxpayers, individuals, trusts and estates, corporations, partnerships, LLCs, anybody who pays self-employment tax. Basically, if you had a return that was due on April 15th, it's now due on July 15th. One caveat to that you will want to keep in mind is that deadline for filing applies for 2019 obligations. And so if you had a deadline that expires on April 15th of 2020 that relates to prior years, that hasn't changed. So for example, a refund claim, if you had a claim for a refund from the 2016 tax year, usually you have to make that claim within 3 years from the due date. So let's say April 15th of 2017, you have 3 years, and that still expires on April 15th. So that's one caveat to the extension of the filing deadlines. So in addition to filings, there has also been an extension of payment deadlines. So income tax payments that were due April 15th now will be due on July 15th. Again, that includes amounts due that relate to 2019. It also includes estimated tax payments for the first quarter of 2020. So the IRS has come out and said that first quarter estimated tax payments, estimated income tax payments that ordinarily would be due on April 15th, those are now due on July 15th. Interestingly, they did not extend the second quarter estimated tax deadline, and that is June 15th. So it's an unusual situation where under the current guidance, the second quarter estimate would be due before the first quarter estimate is due. But we would expect that will be cleared up in future guidance. For state income tax payment deadlines, you got to check in each individual state. They differ. For example, in Illinois, the filing and payment deadline for 2019 has been extended, but your 2020 first quarter estimates are still going to be due on April 15th. So depending on which state you're in, you or your tax advisor will want to check on that. There have been a couple other recent announcements on delays. We expect to see more announcements as this crisis continues. One quick one I know some of my clients have been affected by. There was a deadline of today to restate 403B retirement plan, and that has now been extended until June as well. So if you have any deadlines that are coming up over the next, I would say, month and a half, contact your tax advisor to make sure what the new deadline is. Second thing that we wanted to talk about for the IRS actions relates to a suspension of collection activities. So in guidance that was issued last week, the IRS has effectively shut down their collection function as of tomorrow. According to the guidance that they've issued, the audit function has stopped, so that means there's going to be an indefinite suspension of new IRS examinations. For taxpayers that currently are on an installment agreement with the IRS, they now are allowed to suspend payments under the installment agreement without penalty for the period from April 1st to July 15th. Now, interest will continue to accrue on any unpaid balance, but if you have a crushing need for cash and you're paying on an installment agreement to the IRS, you can suspend those payments without penalty and without violating the terms of your installment agreement. Another action that they've taken is to suspend all new tax liens and federal tax levies. So for those that are kind of in trouble with the IRS, you've got a little reprieve during this short period. Anyone who is dealing with a tax controversy should review what their options are in light of this suspension of collection activities. It may make sense to continue paying in some cases. It may make sense to suspend all of your actions with the IRS. So we recommend that you consult with your tax advisor on what your options are. And then lastly is an area that is getting a lot of attention and is changing very frequently, is a discussion of some of the new tax credits that are being passed in new legislation by the Congress. So the last two pieces of legislation, the Families First Act, which expanded medical leave, and then the CARES Act, which is basically the stimulus bill. Each of those has a different type of new tax credit for employers that you need to be aware of. So the first one I wanted to talk about, the tax credit for emergency sick leave and emergency family and medical leave that would be offered on a paid basis. Those tax credits will apply to any employer that has 500 or fewer employees. And if you are offering paid sick leave or paid family and medical leave for your employees as a result of an impact from the virus, that paid leave will be offset by the employer's obligation to pay trust fund taxes. So federal income tax withholdings, employee portion of FICA, employer portion of FICA. You can use that money that you've withheld from your employees' wages to pay for the sick leave, and then you will get a credit for those payments when you file your quarterly tax returns. That will go into effect tomorrow as well, April 1st. So for filing your first quarter payroll tax returns, that credit does not apply. But going forward, you will be able to use any of those withholding amounts as a credit. Second credit that I wanted to talk about from the CARES Act is an employee retention credit. And that applies to employers that are forced to close due to the pandemic. Basically, the federal government will pay a portion of the wages that you continue to pay while your business is closed. For some employers, that's up to 50% of the wages that you pay, and that's subject to a cap of $10,000 per employee. And some qualifying employers will also get up to a full credit for everything that is all wages that you continue to pay while your business is forced to close. So for employers that are find themselves in that situation where due to a shutdown order, quarantine order, your business cannot continue, if there's a way for you to continue to pay your employees, the government will heavily subsidize that through the CARES Act. The next slide, and what I wanted to talk about next, are issues related to employee benefit plans. We've been getting a lot of questions from our clients about some options that they may want to consider, both with respect to retirement plans and with respect to their group health plans. So starting off with retirement plan issues, when you have employees that are dealing with a significant need, oftentimes their first question is, we need to take an emergency distribution from our 401k plan or profit sharing plan, any plan offered by the employer. And the CARES Act has a new type of distribution, an emergency distribution, and that will allow plan participants to take up to $100,000 distribution from their qualified employer plans, and they can take that distribution without penalty. So it would still be taxed, just like any other income would be taxed. But if you are under age 59 and a half, and you would ordinarily be subject to a 10% early withdrawal penalty, the IRS is now waiving those penalties. In addition, that tax hit can be spread out over 3 years, and if if there is an ability to repay that distribution, the employee who takes the distribution can pay it out over 3 years. The new legislation also expanded the amount of loans that can be taken out from plans. So that's another thing that you may want to consider to offer relief to your workforce. A question that we've been getting a lot of also relates to the suspending contributions to plans. So employers that are faced with a hardship, the question is, can we suspend our employer contributions, whether that be safe harbor contributions or other contributions that an employer is required to make? And the answer is yes, you can. You are allowed to make mid-year changes. We've had a number of clients that have considered freezing some of their plans so as not to accrue any additional benefits under their plans. The only thing that we suggest is that when you're doing those changes, make sure you review your plan documents and make sure that you're offering notices to your participants. Last thing that I wanted to talk about relates to health plan issues and dealing with the consequences of the virus on your workforce. So the first thing to consider with health plan issues, especially for employers that are laying people off, cutting hours, or even closing their doors, that relates to losses of health coverage, losses of employer coverage. If you have a reduction in hours or a termination that results in a loss of coverage, that's a qualifying event for COBRA. So an employer would have to provide COBRA election notice and offer an opportunity for employees to continue the coverage. At this point, there's no need for employers to subsidize COBRA. That's an obligation of the participants. But last time we had a financial crisis, about 12 years ago, there was legislation that offered a subsidy for employers to help their employees afford COBRA coverage. So we may want to wait for federal legislation that could address that. I know that's being discussed now. For plan sponsors that offer health coverage, you also need to consider how you administer the plan in relation to the virus. So there are now legal requirements that plans waive copays and deductibles for employees that are getting virus treatment. So that's something that you also want to consider with your plan administrator to make sure that you're doing that correctly. And then lastly, the costs related to the virus are astronomical, as everyone knows, and we expect that to have a significant impact on employers going forward. So any employer that is weathering the storm right now, we suggest that you start making plans for what you're going to do with your group health plan into 2021. We would expect massive increases in premium costs related to the unprecedented healthcare spending that we're seeing right now. Those are the topics that I wanted to discuss, so I will now turn it back over to Michael.
Thank you, everyone, for attending our webinar on behalf of Hinshaw and our panelists. At Hinshaw, we are here to help you in your business. Please stay safe, and we look forward to connecting with you soon. As I mentioned at the beginning of the program, any questions, please feel free to reach out to Tony, Mark, or myself. Our contact information is on your screen. Stay safe. We'll talk to you soon. Have a nice afternoon.